Hi, this is Professor McLaughlin with a lecture on Chapter 8. This is for Management 12A, Spring 2016. So Chapter 8 covers, let me rephrase, Chapter 8 introduces the next three chapters. Chapters 8, 9, and 10 all have to do with tort law. And so, since the last exam, we have begun to enter into specific areas of the law, whereas the first part of the course, the first 1 through 6 chapters, are about foundations to legal studies, foundations to business and the law. And the remainder of the course will begin to look at how all those concepts, stare decisis and constitutional concepts and concepts of civil litigation and civil procedure, get applied in specific areas of the law. So Chapter 6 we saw international law, Chapter 7 criminal law. Chapters 8, 9, and 10 are a grouping that cover tort law, which is a very large part of U.S. law and a very large part of business law. Tort law is the idea that we hurt each other sometimes unintentionally, sometimes negligently, and we should be able to recover for a wrong that happens to us. And this includes a company that's hurt or a company that does a wrong thing, an individual who's harmed by a company, or an individual who's harmed by another individual. So tort law is the area of law that covers civil wrongs where an injured party would like to sue for compensation, and compensation for an injury. So the purpose of tort law is to compensate innocent injured persons, and it's really important to focus on the language in that first bullet point. And innocent injured persons are persons who did not contribute to their own harm, or weren't also negligent, or doing something wrong themselves. So compensating innocent injured persons is ideally what tort law is about. Tort law also provides a way for injured parties to recover without resorting to private retaliation. So we have a dispute resolution process and the law that governs it that allows people to sue and say, hey, I've been hurt and I would like you to pay my doctor bill, or I would like you to pay for my time off work, or compensate me for my trips to the doctor or my medications. Tort law also ideally helps deter future wrongs. So this is particularly true when we get to Chapter 10 and products liability. I mean, in a perfect world, tort law is a vehicle for people to behave reasonably, for companies to make products that don't hurt us, for people for businesses that deal with the public to have safety procedures and put up cones if the floor is wet and that kind of thing. So those are the purposes of tort law. Torts are classified into three major areas: intentional torts, negligent torts, and strict liability torts. Intentional torts are where a person intends an act and acts and then is responsible for the consequences of that act. So intentional torts, the individual knows or reasonably understands that there will be a consequence to what they do, and they do it, whatever it is, anyway. Negligent torts is where people are subject to unreasonable risks of harm because a defendant is not acting in a responsible way. There's a standard, a duty, and that duty is breached, and someone's behavior falls below a particular standard that we understand to be what a reasonable person would do, what a normal person would do, and not a person acting negligently. Strict liability torts occur when a defendant undertakes an inherently dangerous activity that's likely to cause harm that causes harm to others. And this is a very, very small, specific area of the law. And what I'd like you to understand is that tort law developed over time. Our understanding of how we could be hurt by one another in society, as society industrialized, understanding how companies could make products that hurt us. Each of these areas developed over time through case law. And your chapter will talk about the restatement of torts, but for the most part, tort law is based on the case law, the cases that people are suing and judges are deciding. Strict liability torts are reserved for inherently dangerous activities that are so dangerous that we don't have to show that someone did something knowingly. We don't have to show that someone's behavior fell below a certain standard. Instead, this activity is so dangerous that if somebody is harmed, the defendant is strictly liable. They don't need to show other things. It's kind of a fast track tort. And here you want to think about like people who keep panthers as pets in a neighborhood, boa constrictor pets, people who ship in containers very flammable liquids, mining operations. So activities that are inherently dangerous. Danger is a fundamental part of the activity, and we hold those people strictly liable when harm is caused to others. So let's take a look at some intentional torts, and some of these words will seem familiar and may remind you of Chapter 7 and criminal law, but here I want you to remember we're charging people civilly for a civil tort, so we're only recovering for damages, compensatory damages. We're not putting people in jail. So, for example, on this slide, we're talking about the intentional tort of assault, and then intentional tort of battery, and we call that tortious assault as opposed to criminal assault. And the difference between those two things is that if I sue you criminally, and I get the district attorney to support my suit, you could go to jail. But if I sue you civilly in tort law, tortious assault, I can only get money. I can't, there are no criminal penalties. So assault, battery, defamation. I'll refer you to your book for definitions of all these things, and they will be very similar. Well, for assault and battery, it's very similar to the criminal definition, so really the only distinction is how you're being charged. For defamation, and for these definitions, your book has a very good end of the chapter summary of key topics that defines each of these torts, broken down: torts against persons, intentional torts against persons, intentional torts against property, and intentional torts against economic interests. So those, it's on page 215 in the, which is the big fat number in your book, but it's at the very last page or last couple of pages of chapter 8, a really good summary of key topics. So here, similar to chapter 7, you're looking at elements of a law, and those elements need to be met in order to find somebody liable. So assault under intentional tort law is the placing of another in fear or apprehension of an immediate offensive bodily contact. And each of those elements need to be proven in civil court in order for the defendant to recover. For intentional tort or defamation, another really important tort: intentional publication or communication to a third party of a false statement harmful to an individual's reputation. So here, for defamation, you need to have each of those elements. It has to be intentional. All these torts are intentional, so none of this is accidental. For false imprisonment, so the invasion of privacy torts are very important in this chapter. False imprisonment, you need to have the intentional confining or restraining of a person against his or her will for an appreciable period of time. And the question would be, what's an appreciable period of time? So am I falsely imprisoning you by making you listen to this video? Can I falsely imprison you in my classroom by telling you if you leave, I'll fail you? Is that confining or restraining you against your will for an appreciable period of time? And what if I do that for 5 minutes? Is that appreciable? Do I need to do it for an hour for it to be false imprisonment? So those are things we would have to look at the law in the state of California to see what the answer is. But for our purposes, what I'd like you to do is begin to see the elements of these torts, that they, as you read them in the book, that they are separate concepts and elements that need to be met in order to be liable under this tort. Another student favorite and faculty member favorite: intentional infliction of emotional distress. One would have to engage in outrageous or intentional conduct that is likely to cause extreme emotional distress to another party. So in this chapter, the case that deals with this is the Aaron Olson v. CenturyLink respondent case. Is that this? Where they called, yeah, so it's case 8.2, intentional infliction of emotional distress, where he was hung up on or mistreated, phone service was late in getting connected, and the court looked at the required elements in order for the plaintiff to prevail on intentional infliction of emotional distress. And here defined extreme and outrageous conduct is that behavior which was so atrocious that it passes the boundaries of decency and is utterly intolerable to the civilized community. So you'd need to find a level of outrageous conduct that rises to that definition in order to be liable under intentional infliction of emotional distress. And I'm going to say some of my students, no, just kidding. So take a look at the Aaron Olson case versus CenturyLink. It's case 8.2 in this chapter. Okay, so let's move on to intentional torts against property. And here you're going to have similar elements. Trespass to realty, private nuisance. Private nuisance is a good one. Private nuisance could be a tort if there's an intentional use of one's property in an unreasonable manner that harms the neighbor's use or enjoyment of his own property. So we would have to understand what's an unreasonable manner. If my music is too loud, if my barbecue smoke is disturbing, if and all of that has to harm a neighbor's use and enjoyment of their own property. So if my neighbor is never home, if it's not harming use of his own property, is it a nuisance? And that's a private nuisance, because there's public nuisance as well. Public nuisance would be have to do with the city or that kind of thing. And then conversion, which just is a tort word for theft. Conversion is the intentional, permanent removal of personal property from the owner's possession. So let's move on to intentional torts that are against economic interests. So here, disparagement is really just defamation, business defamation. Intentional interference with contract is super interesting. So think here of a software salesman who knows that a company has a contract with another software seller and is already under contract to use somebody else's software. And so that's software seller B. So software seller A would like to take that contract away. So they convince the company to change. So the elements are that there had to already be a valid enforceable contract in place between two parties. And then the perpetrator of this tort would have to know the existence of that contract and then intentionally undertake to cause one of the parties to breach the contract. So this area, very specific to business and business tort. Another really good one, false misrepresentation. Fraudulent misrepresentation. So fraud covered quite a bit in Chapter 7, criminal fraud. This is tortious fraud, but the same idea. It's an intentional use of a false statement to deceive. So there's deceit. Somebody relies on that deceit, and the deception is to facilitate personal gain. That would be fraudulent misrepresentation. So misrepresenting the odometer in a car, misrepresenting that a product could do more than it could just to make the sale, that kind of thing. And then the other party has to reasonably rely on it. You can't say that this product will make you fly, make people fall in love with you. It has to be a reasonable reliance on a lie. So what do you get when you sue in a tort case? You get damages. And damages are broken down into three kinds. Compensatory damages, which puts the plaintiff in the same position he or she would have been had the tort not occurred. So financially, of course, compensatory damages cannot fix a broken arm or reverse physical damage, but it can reimburse the plaintiff for the cost of that harm. And then nominal damages, where this is where the court, there really is a minimal wrong, the minimal amount of damage, but the defendant's behavior was very wrongful. So nominal damages where the court will say $50 because, there's no compensatory damages, but your behavior was very wrong. And then punitive damages. So these are the very, very popular damages that became, that usually hit the newsstands. And your book in Exhibit 8.6 does a good job spelling out some of the more well-known punitive damages. The Liebeck v. McDonald's case, Williams versus Philip Morris, and the Exxon Valdez case, where the parties received a jury award of punitive damages, and some of those were reduced by the court. But punitive damages are already a area of concern. They can be very large. They can bankrupt a company. Is that what tort law is supposed to be doing? Are we trying to prevent future harm? Or are we causing as much damage as possible in order to ruin a company? And this is where tort reform comes in, and concepts that tort law really has gone overboard, that we are a compensation culture, that every time an accident happens, we just want to be compensated. And those are some of the more those are the more maybe political concerns about plaintiffs' attorneys and how tort law is played out in the courts. All right, I just want to take a look at the other cases and see if we want to talk a little bit about it. So, one final comment. Case 8-1, the two main cases, we already talked about the Olson case, but Case 8-1, the Hatfield v. New York Times Company and Nicholas Kristoff. So this case is about defamation per se. This is a 2005 Fourth Circuit case that concerns some of the activities that followed quickly after 9/11, where anthrax was being mailed or found in certain being mailed to certain persons, and a New York Times journalist, Kristoff, in 2002 wrote an article that made it seem that Stephen Hatfield, who at the time was a researcher employed by the Department of Defense, seemed involved in the anthrax mailings. So this case, so defamation is the wrongful the publication of a false statement to a third party, harming the reputation of a person, of the plaintiff. But this case is about negligence per se, and we call negligence per se is when a statute is violated. So there's a statute in Virginia that addresses defamation, and suing under negligence per se as the cause of action would mean that the statute needed to be violated. And so as you read the case, it goes through the requirements under the statute, how defamatory words are meant to be understood, and the court held that, taken together, these columns by this New York Times journalist were capable of defamatory meaning. They were able to, if read together, to mean a false accusation that Dr. Hatfield was involved in the anthrax mailings. And so, I mean, the ultimate holding of the case is that the district court wrongly dismissed count 1, which is the defamation per se. Okay, so that's chapter 8. It's almost 25 minutes, and I'm going to post this video for you to enjoy, and I will catch you guys next time.